Next matter to come before the court this morning is Sandra Cook versus Sam Bradley et al. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you'd like to reserve some rebuttal time, if you let me know when you get started, I can keep the clock and can keep you apprised of the passage of time. The court has read the briefs and we are ready to proceed when you are.
Morning, my name is Jonathan Rosenbaum. It's my privilege to appear on behalf of Sandra Cook, the appellant. As I'm sure you're keenly aware that today's issue really deals with does the self-protection waiver of the attorney-client privilege extend to subsequent counsel. We respectfully say it does not. I've cited Jackson versus Greger. Apparently I've been taken to task for citing a statute that applies to testimony of an attorney aside from the production of documents and papers. Clearly, as conceded by the appellee in his brief, the common law privilege applies to that as well and is even broader. In Jackson versus Greger, the court also prohibited the production of documents under the word product doctrine. Obviously, in 2010, the Ohio Supreme Court recognized the self-protection waiver to the attorney-client privilege to occur in malpractice cases. Ms. Cook freely concedes that she has waived her attorney-client privilege with Mr. Bradley, but not subsequent counsel. Both sides concede in this case that this has never been addressed by the Ohio Supreme Court. My client and I respectfully submit that to permit the broad application of the self-protection waiver to any and all subsequent counsel would prohibit subsequent counsel from wanting to get involved, would prohibit clients from seeking subsequent counsel and being able to confide in them. Quite frankly, there were 3 lawyers in this case that my client hired to try to correct Mr. Bradley's errors. This case was on the inactive list for a long time with the hopes that they would do that. I filed it to protect the statute. They were unable to help him. It would be counterproductive to now make them produce all of their documents that pertain to direct attorney-client conversations and communication. And we are respectfully asking the court to not do that. The only case that I know of is the one relied upon by the appellee. It's the federal case of Waite-Schneider and Bayless versus Davis. Clearly, in that case, there were extenuating circumstances. There was an extremely detailed in-camera inspection by the district court judge who found that there were simultaneous and overlapping representations that made disclosure of these materials necessary. None of those things exist in this case. This is a divorce case. It's a relatively simple case. It's not complex litigation. There is not overlapping representation. All the subsequent counsel came after Mr. Bradley was discharged. So, again, I respectfully suggest that it was an absolute abuse of discretion to permit the disclosure of all these documents, especially without an in-camera inspection. And I would like to reserve a few minutes.
May it please the court, your honors, counsel. I represent Sam Bradley and Sam Bradley Company LP, and I think the facts which support this claim, the facts that gave rise to the need for Mr. Bradley to file a motion to compel are strongly relevant to a determination as to the legal issue, which is should the self-protection exception to the attorney-client privilege extend to other counsel. There was a pending divorce. Mr. Bradley represented Ms. Cook in a lengthy hearing that resulted in a settlement that was placed on the record. Mr. Bradley has indicated, and the issues that are involved in the malpractice claim arise largely out of pension issues, which are generally in domestic relations cases, resolved in what are called post-judgment orders or QDROs. And it was Mr. Bradley's position all along that these decisions were actually not in dispute, but events that occurred after the termination of the attorney-client relationship caused these decisions, which were really not in dispute and were agreed to become not a part of the order.
And the attorney-client relationship with respect to the divorce, with the subsequent attorneys, has that relationship also been terminated at this point?
I'm sorry, I didn't hear that word.
Yeah, that was a long question. Is the divorce still pending?
The divorce judgment has been entered. So there is a final decree of divorce.
So the attorney-client relationship with the attorneys?
There was no continuing attorney-client relationship with the attorneys from whom we seek to discover this information.
At the time that the motion?
At the time that the motion was filed.
Okay, thank you.
Correct.
Did Ms. Cook, she wasn't Ms. Cook at the time, but when Mr. Bradley was terminated, there was no final decree on the record?
Correct.
Okay, and then there were 2 or 3 other attorneys hired in between, by the time there was a final decree on the record, or filed?
Correct.
Okay, and my question is, what was put in the final decree? Was it issued by the court, or was it a settlement agreement signed by the parties?
It was an agreement signed by the parties ultimately. Procedurally,
Was it ever objected to, or was it ever appealed? Was there ever any objection made by the wife at the time that was done?
Yes, yes and no. The final divorce decree was a consent decree. However, what occurred was a divorce decree was entered by the divorce court, essentially adopting what was placed on the record during the hearing. That decree was appealed. The Court of Appeal, in fact, this Court of Appeals, reversed and remanded and indicated there needed to be a factual hearing to determine the intent of the parties and whether this decree was in fact the final decree.
Was that ever resolved?
That was resolved by consent to include provisions which we contend subjected Mr. Bradley to this claim of malpractice. In other words, what was resolved by consent omitted the terms which plaintiff now claims we should have placed on the record in that hearing in 2009.
In the first place?
What?
Back in the first place.
Back in the first place, yes. And so the point is how, with respect to the final attorney, a gentleman by the name of Mr. Heichi, it's our position that we need to obtain attorney-client communications to determine the decision-making that went into a decision to settle rather than proceed to trial, because the decision to settle is what locked in the malpractice claim.
Why?
Potential liability.
When you went back for a hearing,
Why is it a conclusion that the decision to settle it later meant that there was no malpractice the first time?
No, the decision, the opposite, Your Honor. The decision to settle it and not to litigate the terms that on remand she was entitled to litigate. Those were the terms that she contended Mr. Bradley should have placed in the original decision on the record. So that never got a factual hearing at a trial to determine whether that should have been part of the underlying record. And what we argue, what Mr. Bradley argues, is that he needs to find out what the decision-making, what the advice was from her attorney that led to her decision to sign an agreement that omitted the provision, the specific provision, which she now claims my client should have placed on the record back in May of 2000.
So she was precluded from having the court determine that issue that was omitted in the first place?
Well,
Or could she have gone to trial on that?
Our position is she could have and should have.
But could she not have, My understanding of is placing something on the record that didn't get placed may have been something she desired at the original time, Mr. Bradley. Her claim is that I wanted this on the record, it didn't make it on the record, it wasn't in the judgment entry. He forgot to put it on the record. Now I settled it.
That's her version,
Okay.
yes.
Now I have a subsequent attorney and I decide for whatever reason that I'm going to forego what that was.
I'm not going to proceed to
I'm not
trial
gonna
to
proceed to
determine whether that was in fact part of the original agreement.
When you have an opportunity to do so.
Correct.
And why is that determinative of what happened the first time, whether or not she wanted it on the record? I guess that's,
It's determinative as to whether Mr. Bradley deviated from the accepted standards
but the
by not
standard,
including something on the record that there's now no opportunity to determine should have been on the record. In a subsequent trial.
whether or not she could prevail on something is different than whether or not she agreed to something, correct?
Correct.
Okay, so she's saying, the first time I did not agree to something, the second time I went ahead and agreed to it, not that a factual finding was made, that I wasn't entitled to it.
I completely missed
All right.
your Honor's question. I'm sorry.
So, because perhaps I'm not understanding what happened on the first appeal, but her claim against Mr. Bradley is he failed to put something on the record
Correct.
that was a part of the parties' agreement.
Yes, that's her claim.
She's saying, this was supposed to be on the record based on my understanding of what we were all agreeing to.
That's essentially her claim, yes.
Whether or not the law would sustain that if they went to trial on it. Whether or not she'd be entitled to it if she tried that issue. If she said, hey, he agreed to it and it was supposed to be on the record, and it wasn't on the record.
Right, Mr. Bradley's position is these are generally the types of things that aren't necessarily placed on the record because they are included in post-judgment orders.
Okay, so it wasn't, his position is not that she never told me she wanted that on the record. His position is it wasn't malpractice to fail to put it onto the record.
Correct, correct.
But even in the divorce decree though, it would state, it may not put all the language of the QDRO in there, but at least it's going to state what the division would be of the asset, right? So at least the fundamentals would be there, how we're going to divide it, and then the qualified domestic relations order is going to say all the legal stuff as far as the separate entry, but the separation agreement itself is going to put in there what the division is going to be.
Right, and the issue, the specific issue is not necessarily the division. The specific issue is whether Ms. Cook would have survivorship rights in the federal pension.
That's right.
So the specific issue is really, is it going to be a joint or a single? What's the annuity based on? And I believe Mr. Bradley's position is that that is actually something that's generally placed in a QDRO. And that frankly wasn't really anything that was in dispute until after he was terminated, which I think brings us back, if I'd like to bring back to the initial attorney, Mr. Tony, who was retained immediately after Mr. Bradley's discharge. At the time Mr. Bradley was terminated, there had been no proposed judgment that had been circulated. The testimony is Mr. Bradley had a draft, he was prepared to circulate it. He was prepared to get an extension of time from the court to circulate the entry, at which point he's terminated. Her subsequent attorney then obtains a couple of more extensions, and ultimately, when communication with the husband's attorneys provided, it contains terms Mr. Bradley contends are substantively different than what was agreed to at the divorce hearing. So, with respect to those communications, from the time Ms. Cook first contacted Attorney Tony through Mr. Tony's submission of a letter to the husband's counsel, there must have been communications that led to a determination that they're going to ask for different terms. And then what ultimately happened is the husband's attorney threw up his hands and said, fine, good judge, here's the record, enter it according to the record.
So Attorney Stafford turned over, he was the same attorney the whole time for the
Yes.
husband. And he
For
did,
the relevant period, yes.
okay, and he did in fact say, here's the stuff.
Yeah, we can't agree to the judgment. Here's the transcript. Court just entered according to the transcript, adopt the transcript. And so what Mr. Bradley contends is necessary to defend the malpractice claim is what communications did Ms. Cook have with Mr. Tony that resulted in a letter to the husband's attorney that contained materially different terms, which in turn led to a determination from the husband's attorney to just file a motion with the court to say adopt the transcript. In addition, two other reasons that Mr. Bradley needs these attorney-client privilege communications is, one is basically the statute of limitations. Mr. Bradley contends that he received communications from Mr. Tony prior to the termination of the attorney-client relationship. If so, Mr. Bradley would argue that's a trigger date. And that trigger date may impact the statute of limitations. So we would argue that those communications are clearly relevant and clearly related to a defense of the claim. And then finally...
But you wouldn't have to get into the merits for that.
Sorry?
I'm sorry, I talked to him. You wouldn't have to get into the merits of what the communications were for statute of limitations.
I don't think we would have to get too deeply into the merits. I think we would have to get...
Just the fact that she had new counsel.
About Mr. Bradley's representation. I think that we need to get into the merits enough to determine whether it would reach a trigger event in the Zenny case, which is the legal
In regard to
malpractice.
what the malpractice agreement.
What?
In regard to
Yeah,
what
her knowledge of
the
when it may
I
occur.
agree.
Okay? And then finally, the other reason factually that we need other attorney communications is part of the damages claim in this case is additional attorney's fees that were incurred allegedly to correct Mr. Bradley's malpractice. Both experts in the case acknowledged that there would have been some of the fees that were incurred regardless of whether there was a claim of malpractice or not. In her deposition, Ms. Cook could not provide any of that information, indicated that she did not have bills that she could produce, and what we would need to get into is a task-based acts of these other attorneys to determine what is and what isn't an alleged piece of damages, so that he can defend essentially the damages amount for the subsequent representation. And with respect to the legal argument, I would submit that the Squire Sanders case, which was handed down by our Ohio Supreme Court after the Jackson case, does give this court guidance as to what the Supreme Court would rule if faced with a specific issue. In the Squire Sanders case, the Ohio Supreme Court held that discovery of attorney-client communications between in-house counsel for a corporation and the business operatives of that corporation fell under the self-protection exception. These attorney-client communications with in-house counsel normally would be governed by the traditional attorney-client privilege governed by the statute. So without specifically holding that it applies to other communications, if one were to look at the Squire Sanders case, what in effect the Supreme Court ordered discoverable were other attorney communications through in-house counsel. That argument was addressed, although it wasn't the focus of the Southern District case, the Wade Schneider case. But the Wade Schneider case, I think, is very relevant, and it square on suggested that our Ohio Supreme Court would extend the self-protection exception to the attorney-client privilege in legal malpractice cases to other attorneys. And in that case...
And counsel, I unfortunately need to advise you that you've used your allotted time today. Thank you.
Thank you, Your Honor.
My recollection of what happened here was that There was a negotiation, I think it was the first day of trial. They came in and they were supposed to read the elements, all the elements of the settlement into the record, and Judge Burdick gave them like 2 weeks to produce an entry. Immediately, my client questioned Mr. Bradley as to why these things that she needed and wanted and negotiated for and that they had discussed were in the proposed judgment entries weren't included. Either the day of or the day before the deadline to provide the entry, she inquired of Mr. Bradley if he was going to produce an entry that documented the terms she wanted and she had negotiated for prior to going into court. When that didn't happen, she fired him. Mr. Tony then was consulted. Mr. Tony wrote Mr. Bradley and said, this is what the client's saying. Is this true? And the document exists in which Mr. Bradley admits that these things did occur and that she wanted them and they weren't included. Then there was a fight as to whether or not what entry would be sent to the court. Obviously, Mr. Stafford was not going to agree to anything that my client negotiated for in the hallway, which wasn't included on the record, and he did not. Mr. Barilla came along and appealed the matter, and it was remanded, but it's my understanding that the bottom line here is that my client only got what was read into the record there by Mr. Bradley, or Mr. Stanford, with Mr. Bradley watching and making no corrections or exceptions. There's no chance for her to retry this matter, as I understand it. And these things, as the court has pointed out, should have been in the record, and then the Qdros and the Dopos or whatever would formalize those things. But my client is complaining she didn't get what she was entitled to in the record. That really has, the other 3 lawyers couldn't save it. And I don't believe fees, we don't need to violate the attorney-client privilege to find out what my client paid additionally. In fact, I believe those portions of the files have already been produced. The same applies for the statute of limitations argument. But the Squire Sanders versus Givardi and Flowers case, which created this self-protection exception, says it's the attorney may reveal any confidence that's necessary to defend himself or herself to vindicate his or her rights with regard to disputed issues. It says nothing about extending it to subsequent lawyers. And I submit there is no reason to, but it's also not legally possible, as the law is in Ohio, and therefore, I respectfully submit the trial judge used his discretion in ordering these things, especially without an in-camera inspection. Thank you.
Thank you both gentlemen for your presentations this morning. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides as well as posted on the Ohio Supreme Court website. We adjourn.